And is this really, from where you sit, to recover what a whole range of small businesses would have lost? Or is it something really perhaps to simply teach Eskom a lesson?
Well, it may be a bit of both. We've got to learn more about what's envisaged in this lawsuit. But the principle of a class action is that you essentially take a large number of individual claims and you aggregate them together in a large substantial claim, which ideally then would be adjudicated through the courts. And you'd have a very large pot of money, so to speak, to be shared amongst a potentially very large number of different claimants. There are, however, very significant legal obstacles to the success of such a case.
What are those?
Well, for one thing, there's a doctrine of state immunity, which is that in the ordinary course you cannot sue the state in civil court for its failure to supply your needs. There are, however, exceptions to that. We now have the constitutional right to basic services, firstly. And secondly, to the extent that it's possible to demonstrate that the failure to provide needs or provide for fundamental needs is due to malfeasance or corruption or gross negligence, there indeed there's a possibility of a successful court challenge.
But then if you yourselves expect that there are such obstacles, what then do you think could go in the favor of the people who will be, on whose behalf this application will be lodged? In other words, acknowledging that there are such obstacles, what do you think this particular application has going for itself? And I would imagine it would have to go beyond simply pointing to malfeasance.
Yes. Now, what this application would have in its favor is the Zondo Commission and the what emerges from it. Now, this indeed is potentially a gold mine for a group of applicants or plaintiffs that's trying to show that as a result of corruption, malfeasance, or gross negligence, they have suffered a measurable amount of damages. So, for example, to take the simplest case, a restaurant that suffers an outage and is unable to provide services for an evening, it will then suffer a given amount of damages that's readily ascertainable. In principle, you could say, well, Eskom, as the party that is contractually obliged to be providing reliable electricity, Eskom could be then liable for the damages. The problem here is that Eskom is not a private corporation like any other that acts in the marketplace. It's a rather special category of entity, which is it's 100% state-owned. So essentially, when you sue Eskom, you're not suing a private entity with private shareholders, you are suing the state. And what essentially would be happening is that persons who'd lost money due to power outages are demanding that the taxpayer compensate them. So politically, it's a rather difficult and not to say ambitious legal route. But we have to see what the evidence is and what the causes of actions are as they're presented in the next few days.
Now, apart from the basic services case, are there other cases that you think they might have to rely on as well?
Well, there was a class action a couple of years ago against entities that had allegedly conspired to inflate the price of bread. There have been a couple of other class actions in South African history, but not actually that many. The big class actions that one would look to as precedents here would be in the United States, where, for example, in the wake of the power cuts in California and Nevada, I think in the 1990s, class actions were brought against private power utilities. And in fact, some of those class actions were successful, and some of the power utilities were in fact put out of business because of the success of these class actions. But here we're dealing, as I say, with something completely separate, where these are essentially state corporations. There's no private shareholder to pick up the tab.